Hola, familia. Ask yourself what's more important than your health, your financial health, your well being of you and your family. Estate planning traditionally is something that we Latinos we feel is a burden. We feel we're indestructible, but one that's very important. I've had friends and family not address this, and then somebody in the family unfortunately passes, and it's a burden. You have to deal with a county surrogate. You're dealing with a lot of paperwork, and it's a time when you're emotional and you're trying to take care of other arrangements for a loved one. So you're focusing on things that aren't healthy for you. You want to focus on healing, on taking care of the memory of that loved one, and making sure that Uncle Sam isn't taking too much of that money that was really meant for your family. So if you don't plan properly, it's possible that taxes and um, other conditions, other uh, circumstances will eat away at that money. You want as much as possible to go to your estate, to go to your family, to go to your loved ones, something that you work so hard for. So we're lucky to have our friends at PPAC Private Wealth Management here. We have the fabulous MJ with us, MJ Sully, Esquire. She's their Senior Director, Trust Officer over at PPAC Private Wealth Management. She began her legal career over 12 years ago as a government attorney. She's admitted to practice in New Jersey and Pennsylvania, and recently was a keynote speaker at the New Jersey Institute for Continuing Legal Education during their 56th annual estate planning forum. So somebody that's very well versed on this topic. And we have Tatiana Vivas, who's going to also act as our interpreter. So after each slide, give us a couple seconds. We're going to translate and keep it moving. Hold your questions at the end, send them via Facebook, via YouTube, and we will get to them at the end of the presentation. So without further ado, we have MJ who's going to take us through this presentation. Thank you.
Okay, so first we're going to go through the objectives of estate planning. As I said, or as Carlos mentioned previously, there's going to be plenty time for questions at the end. So I'm going to get through the slides and then just let me know if you have any more specific questions. I'm happy to address them. So the objectives of estate planning are determining which, how, and when family members inherit. Um, Here we go. Designating fiduciaries in a will or trust, including executors, trustees, and guardians. I think it's the next page. Right. Okay. We're on the third bullet point there, designating an agent to effectuate healthcare decisions and or financial decisions in case of disability and providing for your healthcare. Planning for orderly succession of ownership of a family business, protecting against creditors and or spendthrifts, minimizing federal and or estate income, estate, gift, or inheritance taxes upon transfer, and ensuring that the surviving spouse and or family members have sufficient liquidity upon death to meet immediate needs, which may include funeral expenses, estate tax, mortgage, and other expenses.
Hola familia, buenas tardes. Entonces el día de hoy estamos hablando sobre la importancia de la planificación familiar, la planificación patrimonial dentro de la familia, porque es importante aprender de esto. Y tenemos a MJ, quien es directora senior de la gestión de patrimonios del PIPA Gladstone Bank, quien nos está hablando un poco sobre este tema. Y los objetivos de la planificación patrimonial, primeramente, es determinar qué miembros de la familia heredan, cómo y cuándo lo hacen, también la diferente designación de los fiduciarios en un testamento o un fideicomiso, la designación de un agente para que tome decisiones sobre la atención sanitaria y decisiones financieras en caso de incapacidad o la previsión de la atención sanitaria, también planificar la sucesión ordenada de la propiedad de una empresa familiar, la protección que hay también contra los acreedores, minimizar el impuesto federal, como mencionó Carlos también, es muy importante. y establecer el patrimonio, las donaciones o las herencias en el momento de la transmisión y sobre todo garantizar que el cónyuge superviviente o los miembros de la familia dispongan de liquidez suficiente e inmediata en lo más posible.
Thank you. I just want to, if I may, just kind of go back to where I talked about the last bullet point on this previous page, on this page right here, where I say ensuring that there's sufficient liquidity. That's important because, say, you have someone who has plenty of assets, but their assets are all real property. Okay, so when you have 6 months and then 9 months to try to pay taxes, obviously it can get pushed. You can kick that can down about 6 months if you file an extension, but you have taxes due, and if there's no liquidity, you then have to have a fire sale to sell a piece of property or whatever the case may be. So it's important to provide for to have plenty of liquidity in your estate, and that can be done through uh, insurance policies or whatnot, because you don't want to have somebody, your estate, have a bunch of real assets, no liquidity to pay the taxes, and then, as I said before, they have to quickly sell and maybe not get the best price on the property that you have. So that's why that's important, and I just wanted to drive that point home.
Entonces, el último punto que se mencionó sobre garantizar que el cónyuge, las personas supervivientes, los miembros de la familia dispongan de liquidez inmediata, es porque debe ser suficiente también en el momento del fallecimiento. Muchas veces se encuentran con asuntos en que necesitan, por ejemplo, pagar los impuestos, tal vez tienen 6 o 9 meses para hacer todos estos pagos y lamentablemente van a tener que vender propiedades a un precio mucho más bajo. Entonces es muy importante que tengan la liquidez inmediata para poder hacer frente a las necesidades inmediatas que pueden incluir, por ejemplo, gastos funerarios, impuestos sobre el patrimonio, hipotecas. Entonces es muy importante que tengan eso en mente.
Thank you. Okay, issues to address in estate planning. The asset type, the asset values. This is very important. How are assets titled and who are the beneficiary designations, and should they be changed? Guardians for minor children, obviously subject to the right of the surviving parent. And should that guardian of the child also be the trustee of the children's funds? Should that be the same person? And the difference is guardian basically of the person, which would be like deciding on schools, deciding on doctors, choosing pediatricians for the children, versus having someone invest the child's funds. These can be bifurcated to different people, or it could be the same people, but you want to think about who has the wherewithal to, some people are better with money than others. So obviously, and some people are better with just children and raising children than others. So if you have one person that's good with money, one person that's good with basically raising children, and that you respect that they're going to raise them in the way you would want them raised, you might want to go with two different people. So these are just all important considerations to make.
Entonces, algunas de las consideraciones que se deben tener dentro de lo que es las cuestiones de planificación patrimonial son los tipos de activos que se tienen, el valor de los diferentes activos y los títulos también de los diferentes activos, cómo se titulan, cuáles son las designaciones de beneficiarios y si deben modificarse cada tiempo o no. Entonces, por ejemplo, debe haber un tutor de los hijos menores quien está sujeto a los derechos del progenitor superviviente. Debe ser la misma persona, el tutor de los hijos y el fideicomisario de los fondos de los hijos. Queremos que la misma persona que cuide, por ejemplo, a nuestros hijos en este caso, sea la misma persona que esté a cargo del movimiento de dinero que también se le dejó. Entonces, hay maneras en que se puede bifurcar esto hacia dos personas, porque una persona puede ser muy buena con el dinero y otra persona puede ser mejor con la crianza, o si esa persona tiene ambas habilidades, entonces también podría ser la misma.
Thank you, Tatiana. I also want to stay on this slide. Can you go back? I'm sorry, stay on this slide for one more thing. I also want to talk about, and this is really important, how the third one down, how assets are titled. What are the beneficiary designations, and should they be changed? Um, as uh, as as Carlos said earlier, I was with the courts for about 10 years. And so all I did was work with the judges on a, a, a state litigation. And a big part of where things went wrong and they had to be litigated and obviously brought to court, which is expensive. Nobody wants to have to go to court if they don't have to, was because of the asset titling. People would have these wonderful wills that reflected their intentions exactly. They had two sons, just for example, they wanted 50% to go to one son and 50% to go to the other son, and that's what the will said. No ifs, ands, or buts. Clear as day what the intention of the testator, who is the person that's making the will, wanted. The problem is that titling, all their assets were titled because one son, say, was close by, the other son was far away. So the one son that was close by was helping, and she put say it was the mother put that one son's name on all her accounts. Well, if they're put on with any kind of joint with right of survivorship, that passes not through the estate. It passes what's called by operation of law to the surviving joint owner. So even though the will said 50-50, that only speaks to probate assets. And a joint account with right of survivorship is not a probate asset. That passes by right of survivorship to the surviving joint owner. So we would see in court a lot of issues where the other son that wasn't close by was like, but I know my mom wanted it 50-50. And the answer is yes, she did. She wanted her probate assets to go 50-50, but that was not a probate asset. And unfortunately, the mother didn't realize that that's how it worked, that by putting her other son on the account with her, that it was no longer a probate asset and now is going to pass only to that son. So that's why titling is very, very important. The other way that it's very, very important is if you want the asset to be in a trust, an Intervivos trust, a trust while you're alive. Well, the only way that it's going to be in the trust is if it's titled in the trust. Because if it's titled just in your name, it's going to pass to your estate. So those are just some examples of why it's important to pay attention to how your assets are titled, to make sure that the end result, what you want in your will, jives with how the assets are titled.
Entonces, regresando a la última diapositiva de cómo se titulan los activos, cuáles son las designaciones de los beneficiarios y si esto deben de modificarse, es muy importante tener en mente, MJ mencionó que ella lleva ya 10 años trabajando, que ella llevó 10 años trabajando en las cortes, y algo que siempre encontraba dentro de los casos con los jueces y la litigación estatal es que, por ejemplo, si una persona hacía una división en un testamento de un 50% para un hijo y un 50% para otro hijo, pero en este caso, por ejemplo, la madre, quien falleció, tenía una cuenta conjunta con un hijo con el que estaba cerca, el peso recae sobre la cuenta conjunta, a pesar de que la madre decide, por ejemplo, que quiere 50% para un hijo y 50% para el otro. La persona dueña de la cuenta conjunta, junto con la persona dentro de la cuenta conjunta, básicamente es la dueña de la cuenta. Entonces, lamentablemente, tienen que estar bien titulados cómo se hacen todas estas partes del activo testamentario para que pueda ocurrir exactamente lo que quería que ocurriese antes de fallecer la persona.
Thank you, Tatiana. Now we're going to talk about powers of attorney. Um, power. So there's a bunch of different documents that I think and I would recommend that everyone have. We're going to talk about powers of attorney first. When is a power of attorney effective? It's effective upon signing, or it can be effective upon the principal becoming disabled. And this is called a springing power of attorney. If it's springing, which I'm not a big fan of the springing. That the springing kind of goes like, once I become incapacitated, then my son can be my act as my attorney in fact under this power of attorney. The problem is when you take that to a bank, the bank it now says the condition precedent is that you have to be incapacitated. When you bring this to a bank, the bank manager, they have no expertise on whether or not you're now incapacitated. They're going to say, we need doctor's notes, or we need a court order saying that you're incapacitated. So I don't like the springing document, because it will, I think it lends itself more to you having to go back to court, or having issues with the bank and not being able to, or whoever you're trying to use it with, and not being able to use it. I like the non-springing, so it's effective when you sign it, but you may say, well, listen, I'm perfectly competent now. I don't want anybody to act for me when I'm perfectly competent. Well, the key to that is you would just keep it, in your drawer or in your file, and then tell that person, when something happens to me, they can then use it. You know what I mean? So it's ready to go, and that person who you've designated as the attorney in fact can just say, God forbid, if you got in an accident and are in a coma or unconscious for whatever reason, they grab the power of attorney, and now they can act, and they don't have to prove to a bank or anybody that you are incapacitated. It's just effective as is.
Ok, entonces vamos a hablar un poco sobre lo que son los poderes notariales y lo importante aquí es saber cuándo entra, por ejemplo, en vigor algún poder. Y el poder entra en vigor en el momento, si entra en vigor en el momento de la firma, o solo entra en vigor si el poderante queda incapacitado. Entonces hay un tipo de poderes que se llaman el poder de resorte. MJ dio un ejemplo de que, por ejemplo, a veces es muy difícil utilizarlo dentro de un banco en donde, por ejemplo, un hijo tiene todo el poder, como el de un abogado, para poder hacer uso de todo esto, pero debe demostrar una condición de incapacitado, que normalmente el banco, donde hay un gerente que tal vez no tiene experiencia en poder definir la capacidad o no, necesita una orden directamente de un juez o también de un doctor. Entonces, tienen que darse cuenta si ustedes tienen un poder notarial que es resorte o de no resorte, básicamente, en donde hay otro que solamente se firma y, por ejemplo, se lo tiene en el cajón guardado, y si Dios no quiera, ocurre un accidente, están en un coma, automáticamente la persona que queda como ponderante básicamente solamente lo saca de allí, lo puede llevar y puede hacer cualquier tipo de movimiento.
Thank you. Okay, power of attorney mileage. The general rule is that a power of attorney terminates upon the incapacity of the principal. Therefore, for a power of attorney to remain in effect beyond the principal's incapacity, it must contain the following language: that the power of attorney shall not be affected by the subsequent disability or incapacity of the principal. The inclusion of this language makes it a durable power of attorney. And all powers of attorney, durable and non-durable, automatically terminate upon the death of the principal. So I know I've spoken to people and they're like, oh, do you have a will? I've asked them if they have a will, and they're like, no, I have a power of attorney. Well, the power of attorney ceases to act once you die. So a power of attorney is not a replacement for a will. A power of attorney is a replacement for if you need someone while you're still alive to help you, whether you're incapacitated or not incapacitated, depending on what the provisions of the power of attorney provide.
Entonces, ¿cuál es el kilometraje de un poder notarial? La regla general es, según el derecho común, es que el poder se extingue en caso de la incapacidad del ponderante. Por lo tanto, para que el poder pueda estar siempre en vigor después de la incapacidad del mandante, debe contener el siguiente texto. Primero, que este poder no se verá afectado por la incapacidad subsiguiente del ponderante. Segundo, que la inclusión de este lenguaje lo convierte en un poder duradero. Y tercero, que todos los poderes duraderos y no duraderos se extinguen automáticamente en caso del fallecimiento del ponderante. Y es aquí donde muchas personas cometen el error porque piensan que por el hecho de haber hecho un poder notarial hicieron un testamento y básicamente el poder notarial se extingue o se termina en el momento en que la persona fallece. Y siempre le pregunta MJ a las personas pues, que sí han hecho testamento, muchas veces solo han hecho un poder notarial y es ahí donde se trabaja en que el poder notarial es distinto a lo que es el testamento.
Okay. Agents. So an agent and an attorney, in fact, that's kind of the same designation for the person who's going to act, who's the person's going to act on your behalf. Okay. Should you name a successor? Yes, you should, because God forbid if something happens to the person that you named, and now you have this power of attorney that can't be used because you named one person and didn't make provisions for a second person if anything happened to that first person. And that also includes if they decide not to do it. Just because you name someone doesn't mean that they're actually going to accept the designation. And we're going to talk a little bit more about that later, but I just wanted to mention it now. So it is a good idea to name a successor. And the successor only has the power to act if the primary dies, resigns, or becomes, again, disabled. It cannot merely be because they're unavailable. So, in other words, if they cannot be reached, if they've gone on vacation, you name somebody, and then you have a successor, and they're going to say, you're going to take it to a bank, and the bank is going to say, well, I see that Jane Doe is your initially named attorney, in fact, but you're John Doe and you're the successor. Well, either show me a death certificate, a resignation from Jane, or letters of incapacity. Otherwise, you can't act. So, how do you solve for this? Well, you can have multiple agents. You can name two. If you do that, and this is a great idea because this way, if one's not around, the other can pick up. But if that's how you want it to work, you must designate that you want them to act separately. Because if you designate that you want them to act jointly, which is the default in New Jersey, then you're right back to where you were. If they have to act jointly, then you need them both to, ask the bank to move $50 from your savings account into your checking account or whatever you're trying to accomplish. Again, if that Jane Doe is on vacation and they have to act jointly, John cannot act without her. So my advice would be to give them the ability to act separately. And the document must indicate that because, as I said before, the default in New Jersey, if it's silent, is the understanding is that they must act jointly.
Dentro de lo que son los agentes hay que tener en consideración si el poder prevé un agente, un abogado de hecho y también si se prevé un sucesor. Es importante siempre tener un sucesor que puede actuar en el caso de que el agente designado fallece, renuncia también de tener esa responsabilidad o se encuentra incapacitado. Se puede denominar también dos agentes distintos que pueden trabajar simultáneamente o que pueden tomar decisiones por separados. El sucesor solo tiene poder para actuar si el agente, como mencionamos, fallece, presenta una renuncia por escrito o queda incapacitado. El sucesor no puede trabajar en el caso de que no hayan podido contactar a la gente.
Okay, thank you. Revocation. Does the execution of a new power of attorney automatically revoke the prior power of attorney? The general rule in New Jersey is that execution of a new power of attorney does not automatically revoke the prior power of attorney. The power of attorney must specifically provide that the prior one is revoked. And so this is important to do because, again, just giving you some insight into my previous life in the courts, there would be litigation. They would say, there would be maybe the son was the first power of attorney, the daughter was the second power of attorney. The second power of attorney didn't revoke the first power of attorney. Then the agent in the first power of attorney would say, well, it wasn't a valid power of attorney, so I still should be able to act, and it just becomes a big mess. So you want to, if you're going to revoke it, you want to specifically refer. I had a power of attorney, 10 years ago that was made on October 12th, 2013. I'm now revoking it in favor of this new power of attorney, and problem solved. So it's just a matter of putting your intentions to avoid any misunderstandings.
Entonces, la revocación ocurre en la ejecución de un nuevo poder, revoca automáticamente cualquier poder anterior. La regla general básicamente indica que el otorgamiento de un nuevo poder no revoca automáticamente el anterior. El poder debe establecer específicamente que los poderes anteriores queden revocados. Entonces, es algo con lo que se debe trabajar en el término legal, la revisión de todos los poderes notariales al mismo tiempo.
Terrific. And just this whole revocation issue under the power of attorney is governed by a rule of court, and it says that a power of attorney is revoked when the principal has caused all executed originals of the power of attorney to be physically destroyed, or when the principal has signed or caused to acknowledge that the written instrument has been revoked. So that's an important point. Next is gifting. Now, gifting under a power of attorney, if you want to, and you may not want to, but if you want to give your attorney in fact the ability to gift, then you need to specifically have that language in your document, because gifting is not permitted unless the power of attorney specifically authorizes it. And you may want to think about, if you do want a gift, you may want to put, a limit on the gift that my power of attorney has the ability to gift. They may do so, not more than $5,000 a year per person. Just to limit it. If that's what you want, you should put it in there. Also, you may limit the class of the donees or the gift recipients, if you will. In other words, they giving the principal the ability to gift to your children. Not just anybody, right? To only your children. So that's another important issue that the document should provide for.
Entonces, dentro de lo que son las revocaciones, solamente pueden ocurrir en el caso de que la persona principal que está haciendo el documento pida por escrito que los poderes anteriores queden revocados. Y cuando se trata, por ejemplo, de regalos, no está permitido que un agente haga regalos en virtud de un poder, a menos que el poder específicamente lo autorice por escrito, ¿no? Y si se autoriza el regalo, tienen que tener en mente diferentes preguntas. Por ejemplo, si existe un límite en el importe de la donación, cuál sería, y si existe algún límite en cuanto a la clase de donatarios, por ejemplo, los hijos de la persona principal.
Okay, great. Next, we're going to move on to banking. If a power of attorney contains specific language which allows the agent, the attorney in fact, the authority to conduct banking transactions, then the banks must honor. But The bank may refuse to honor a valid power of attorney if it's more than 10 years after it's executed. And I can tell you that that 10-year rule is pretty hard and fast. I've never really seen where it's over 10 years and the bank's like, we'll let it ride. No. So you really need to stay on top of your documents. Not so much with a will if nothing has changed in your life, but definitely with a power of attorney. And we're going to get to healthcare directives. Those should be updated periodically because, as I said, if they're too stale, either a bank or a hospital will be uninclined to follow them.
Dentro de lo que es la banca y el poder notarial, básicamente si un poder contiene lenguaje específico que confiere a la gente la autoridad para realizar diferentes transacciones bancarias, entonces los bancos deben siempre honrar este poder notarial. Pero por el contrario, si por ejemplo el poder ya tiene más de 10 años después de que se ejecutó, básicamente el banco no va a aceptarlo. Y MJ mencionó que han habido muchos, que rara vez, que de hecho no ha visto ningún caso en el que el banco diga sí, lo vamos a aceptar de todas maneras aunque haya pasado los 10 años, así que tienen que tener siempre presente eso cuando se trata de un poder notarial, a diferencia de un testamento o directivos de salud de los que va a hablar un poquito más tarde.
Okay, real estate. If using a POA, a power of attorney, to sign any real estate documents that get recorded, like a deed or a mortgage, the power of attorney must also be recorded. And only an original power of attorney can be recorded. This happens quite a bit. Sometimes if someone is, older, they can't live in their home, so they end up living with somebody else, or they go to a healthcare facility, and to help defer those costs, they want to sell their house to pay for the because that's a lot of people's biggest asset is their home. So they want to sell the home, and the power of attorney wants to assist and get this done. So they'll need to, obviously that involves, signing deeds and mortgages and whatnot. So if you have a home, you want to definitely make sure that language regarding giving the power to your power of attorney to sign real estate regarding real property, that you include that language. And also, importantly, only, as I said here, only an original power of attorney can be recorded. So you really you can only have one will, only one original will you want. But when you're executing powers of attorney, you want to do a bunch of them, because a lot of times the banks that you're dealing with, obviously to sell the house, to record the new deed, you have to use an original. And sometimes banks will be like, well, just show me the original, I'll make a copy and I'll give it back to you. But some banks want to keep that original, so you want to have several, 5, 6 original powers of attorney on hand. This way, if they get used up, and you don't have any more, and the next bank that you want to deal with wants an original and you can't give them because they're all gone, you want to make sure you have plenty so that doesn't happen.
Dentro de lo que son los bienes inmuebles, se utiliza un poder para firmar cualquier documento inmobiliario que se registre. Es decir, una escritura, por ejemplo, una hipoteca, el poder también debe estar registrado dentro de lo que son estos asuntos de bienes inmuebles o real estate, y solo se puede registrar un poder original. Es decir, si por ejemplo hay una persona que ya es un adulto mayor y en algún momento desea ir a vivir a un asilo y desea vender su casa, básicamente el poder debe estar ya registrado y debe ser un original. Solamente va a funcionar si es un original. Quiere decir que tiene que tener 4 o 5 tal vez de estos documentos originales, porque rara vez van a ver un banco que diga, sí, le saco copia a este original y me quedo con las copias. Los bancos normalmente se van a querer quedar con el documento original, así que es importante que tengan más de uno.
Thank you. Okay, we're going to talk about disclaimers. Disclaimers aren't very, very common, but if you want to give your power of attorney the ability to disclaim on your behalf, then your document, your power of attorney, has to expressly authorize that. And if no such language is in the document, you're going to need court approval. And again, that's costly. So you want to, if that's something that you want to your power of attorney to be able to do, you want to include that language. Just so you know, a disclaimer is a repudiation, refusal, rejection, or renunciation of a claim, interest, or right. And this happens sometimes, like if say a husband dies and he leaves his estate to his wife, and that passes, tax-free husband to wife transfer. Anyway, on her death, obviously, her spouse has already passed away, so it's going to go to the kids, and that would be a taxable event. So what she might want to do is disclaim part of part of what her husband leaves to her. So that'll pass to the kids upon the first to die, and then upon the second to die, you know, uh, she can take advantage of her lifetime exemption. So it can be a disclaimer can be used in order to avoid taxes and to get money to like the next generation, with the least tax consequences. So I just wanted to mention disclaimers because they are useful tools. Okay.
Entonces existe también la parte de poder hacer un descargo de responsabilidad, en donde un agente bajo el poder puede renunciar en nombre de un mandante, pero solo si el poder lo autoriza expresamente. Si no existe tal autorización, se necesita la aprobación de un tribunal para poder renunciar. Así que es muy importante que tengan también estas palabras dentro de lo que es el poder notarial. Es muy importante también saber que el descargo de responsabilidad se utiliza muchas veces para poder obtener los beneficios de los impuestos.
Okay. The execution of a power of attorney. Okay, this is important. It must be signed by the person, who is making it, right? It must be notarized. In New Jersey, a power of attorney does not have to be witnessed, but it's a good practice to do so, and I would recommend that it also be witnessed. In New York, unlike New Jersey, a power of attorney must be witnessed, and the attorney, in fact, the agent that you designate in New Jersey, does not have to sign or execute in order for it to be valid. But in New York, they must sign or execute the power of attorney for it to be valid.
Entonces, cuando se trata sobre la ejecución del poder notarial, primero que nada debe ser firmado por la persona que lo está realizando, sería la persona principal. Debe ser también notariado. No tiene necesariamente que ser atestiguado, pero NJ recomienda que es una buena práctica de hacerlo si existen testigos que pueden firmar también. En el estado de Nueva York debe ser por ley atestiguado, y el agente o el abogado, de hecho, para el poder notarial en Nueva Jersey tiene que ejecutar y también firmar, y el agente o apoderado dentro de Nueva York también debe ejecutar y firmar.
Okay, moving on to last will and testaments. Why can't I see anybody? Why can't I see? I can't see anybody. Am I still connected? Hello?
We could hear you, and we are
Oh, you
on.
can hear me.
last
Okay, I
will
got
and
you back.
testament. Yep.
Sorry about that. Okay, I got you back. I don't know what happened there. Sorry. Because this is my favorite part, last will and testaments. Okay. So, we're going to talk about the validity of last will and testaments. Now, it's important to know the location of the original will. There should only be one original last will and testament, and it's so important to know where that original is. You want to give copies to people, that's fine, but if you don't have the original and your heirs don't know where it is, you're going to have an issue because the surrogate will only probate an original will. Um, the deal is that if you cannot produce an original will, there is a rebuttable presumption that you can't produce it because it's been revoked, right? It's been obliterated, thrown out because that is what the testator, who is the person that's making the will, that's the term for the person making the will, has destroyed the will. Okay, but as I said, it's a rebuttable presumption. It can be rebutted by the standard is clear and convincing evidence, but the problem is you have to make that proof to the superior court, not the surrogate's court. So it can't be probated in what's called common form, which is you just go to the surrogate. You don't need a lawyer. It's pretty quick. It's pretty inexpensive. It's very easy. They probate it and they give you your letters testamentary, memorializing that you're the executor. If you can't give them the original, then you have to go through the superior court, order to show cause, verified complaint, an attorney. The process is more expensive and it takes a lot more time. So you want to make sure that you know where your original is. The other thing too is don't put the original in a safe deposit box in your name, because you passed away and the bank is going to need to know who the executor is of your estate, and they're only going to let that person in. And but you can't have an executor of your estate unless you take the will and probate it. So it's like a catch-22. The original will is in the safe deposit box. You need letters testamentary that you get once you probate the will in order to open the safe deposit box, but that you need the will in order to get those letters testamentary. So it's not a good idea to put them into a safe deposit box with only your name on it. Okay. If you want to put it with somebody else's name on it that you trust, or maybe the executor, whoever you named as the executor, then fine, they can go in and get it. Or if you want to buy a fireproof box and, keep it in your home under lock and key, that's probably a good idea. But never, never, never put it in a safe deposit box in your name, because it just is very difficult to then get it out. And there's just no need for all that extra headache.
Entonces, cuando se trata sobre las últimas voluntades y también los testamentos, hay que reconocer mucho la validez del mismo. Se debe conocer la ubicación del testamento original, que lo debe de conocer sobre todo la persona que queda como agente designado. Se debe asegurar de que haya sido atestiguado por dos personas, que no haya sido roto ni nada de eso. Y algo muy importante que mencionó MJ es que no se lo ponga en una caja de seguridad del banco al nombre de la propia persona principal. Debe ir dentro de la caja del agente, quien va a ejecutar ese testamento, o otras personas, o incluso se lo puede tener dentro de una caja fuerte dentro del propio hogar, pero no necesariamente debe ir al banco, porque lamentablemente es lo que tiene el permiso para que la otra persona vaya a retirarlo y pueda abrir esa caja fuerte. Entonces es algo que se necesita para poder abrir, de hecho, la caja fuerte del banco.
Thank you. Also, to make a will valid in New Jersey, it must be witnessed by two persons. And an issue is it self-proving? The self-proving statute came out in the 70s, and it was necessary because before that, people kind of stayed locally. But then people started moving around, and moving away from home became a lot more common. And so if you had, your brother or sister witnesses, right? They would then, and they moved away to California, you would have to have them sign this what's called a witness proof, so you could give it to the surrogates court so they could, because that's a form that they need to see that the will is witnessed, and then they need a witness proof that basically where the witness says that the testator was 18 years or older, of sound mind, and under no undue influence. So they would basically have to sign it. Then in the 70s, they came up with the self-proving affidavit, which is just an extra piece of paper that gets executed and is made part of your will, where that's all done. So you don't have to chase people, all over the country or the world to try to execute upon your demise these witness proofs. So I highly recommend that if when you get a will, that you make sure that it is self-proving. Okay.
Dentro de lo que es la validez también de un testamento es muy importante que sea atestiguado por dos personas. Antes no había ningún problema si había alguna declaración juramentada, pero el que sea atestiguado por dos personas lo convierte en self-proving, que básicamente muestra de por sí solo que es un documento original, ya que fue firmado no solo por la persona, sino también por un testigo.
Thank you. Another issue is, has the will been defaced or unstapled? And this becomes an issue when you're trying to probate the will in common form. If it's been like ripped and taped up, or if it looks like it's been pulled apart and restapled, the surrogate is going to, because the surrogate has limited power. If there's any doubt about it being a bona fide will, they have to deny probate, and then you'd have to then go probate the will in, and as I said before, solemn form, which is through the superior court. So you want to make sure when you have your will, you keep it safe. You keep it, don't be, if it's ripped, you probably want to do a new one because you don't want to have your heirs have to go through a solemn form superior court application with lawyers when they can just basically go down to the surrogate's office and, as I said, pretty quickly and inexpensively probate your will as is.
Algo que también se debe asegurar para la validez del testamento es que no haya sido desfigurado el papel maltratado, que haya sido despegado de las grapas. Básicamente se debe demostrar que es el documento original que se hizo, y en todo caso, si es que el agente que va a ejecutar el testamento desea utilizarlo con todos estos asuntos, debe de probar en la Corte Superior que es un documento original.
I just want to talk about codicils very quickly. A codicil is an addition to a will, if you will. So if you want to change your will and there's not a lot of changes, maybe just like one article you want to change because your children are now adults, and so they don't need guardians of their person and property, you can just prepare and execute what's called a codicil, and that'll address, it'll address the will, and you would probate it along with the will, and it would make the changes. My recommendation is, if you're going to do any kind of major changes, especially after like a divorce or something like that, you want to just redo your will, a brand new will where you revoke the original one, as opposed to a codicil where you just revoke the specific article of the previous will. But anyway, that's just another way around, if because things change and you may want to tweak your estate plan. So that's just another way to do it that I just wanted to make sure you all knew about.
Algo muy importante también de tomar en consideración son los codicilios, que básicamente son las modificaciones existentes dentro de un testamento. Por ejemplo, si quieren hacer un cambio menor dentro de un artículo en donde básicamente se habla, por ejemplo, si los hijos ya son adultos, no necesitan tutores, se cambia una o dos líneas o un artículo completo sin ningún problema. Pero si ocurren cambios mayores, por ejemplo, un divorcio, y se quieren hacer algunos cambios distintos, es mejor que siempre se haga la revocación del testamento anterior y que también exista el Nuevo Testamento.
Thank you. Next, I want to talk about personal property. If a client has valuable collections and antiques, um, do you want that to pass as the general residuary clause, or do you want to do a personal property clause, a specific bequest? I leave my, silver tea set to my niece, Jill. Anyway, what is the method or mechanism of distributing tangible personal property? Well, you can, put it in the will as a specific bequest that I just said about the T set, or there's also a under NJSA 3B 311, you can just do a separate written statement or list that where you can dispose of tangible personal property. This is a nice way to do it because a lot of times, I know like Hummels were a big deal at one time and people were into Hummels. And then, some people, one person said, "Oh, I want your Hummels." And so you want to leave them your Hummel in your will. And then they're like, "I'm not really into Hummels. Leave it to my sister instead. She's into Hummels." So if you put it in your will, you then have to do either a codicil or a new will. But if you use this list that the law allows you to create, you can basically the will just refers to this written statement or list that disposes of specific items of tangible personal property. And also it can be in your writing, it can be just typed and signed. It must describe the items. If you have several tea serving sets, you want to, like the silver one versus the Wedgwood one, or whatever the case may be. But anyway, it can be prepared before or after the execution of the will. And then, as I said, it can be changed, so without having to change the will. So the will is going to refer to this list, and then you just make sure that you keep it in a safe place, and that will dispose of your personal tangible property, even like your automobile, anything that's tangible, not real estate. So anyway, that I know a lot of people change their mind about different things that they want to give away to different people. So this is a way to do it pretty quickly and easily, and without having to get a lawyer involved to redo a will or do a codicil.
Entonces, cuando se trata sobre los bienes personales, si el cliente tiene colecciones, antigüedades valiosas, se deben preguntar si pasarán como parte de una cláusula general de bienes personales o tangibles, cuál es el método o mecanismo para distribuir esos bienes personales tangibles. Debe el testamento hacer referencia a la existencia de dicha lista. Entonces, ustedes pueden encontrar una lista completa, que es una declaración o lista por escrito para disponer de los bienes personales tangibles, bajo la ley NJSA 3B 2.3-11, en donde básicamente les demuestra también qué hacer con todos los bienes personales y cómo proceder dentro de un testamento a detallarlos.
Thank you. Okay, I referenced a specific bequest when I was talking about personal property, because a specific bequest is, when you put it in your will that the T set is going to go to a specific person. The opposite of, or the inverse of that would be a residuary bequest, where you just say, like, the rest, residue, and remainder of my estate, which is usually how the bulk of the estate passes, goes to, to be divided equally among my 3 children. And so this usually includes, like, if you don't want to, if you don't want to give the real estate to just one person or 2 people, you want to give it to everybody, you make that part of your part of the residuary bequest. So as an example, you can just say something like, I leave my personalty pursuant to a list that I've drafted and kept, in a drawer in my bedroom, and that's the list that we talked about. And the rest, residue, and remainder of my estate is to pass as follows: 1/3 to son 1, 1/3 to son 2, and 1/3 to my daughter. So that's just the difference between what a specific bequest is and a residuary bequest.
Entonces, dentro de lo que se trata de bienes personales, un testamento puede referirse a una declaración o lista escrita para disponer de los artículos de propiedad personal tangible, en donde se puede hacer una petición específica o una petición abierta de cómo se van a dividir esto dentro de las personas que son beneficiarios. Entonces, para ser válido el escrito, debe ser de puño y letra del testador o estar firmado por él y debe describir los artículos y los legitarios con una certeza razonable.
Thank you. Now, also, your will may include, you may be charitably inclined and you want to include charitable bequests. You should think about whether you want to give it to a local office or a national office, and it should be specific. So your executor knows exactly who you want to get that. Because there's local chapters of, say, the Salvation Army, and then there's the national. So you want to help your executor be able to facilitate your intent. So you want to be as specific as you can. Also, you may want to consider providing for a charity from your IRA rather than from a non-qualified account. Why is this a good idea? Because if you leave money to a heir through an IRA, that IRA money hasn't been taxable. So when the heir takes that money out, it's subject to tax. Unlike charities, that they're immune to tax, that an individual is not. So if you give an IRA distribution, if you make an IRA, either, I leave half to, if you're charitably inclined and want to leave something to the Salvation Army, do it out of your IRA account, because they're not going to end up paying tax on that. Whereas if you make it payable to, your sons or daughters, that they're going to get tagged, because, as I said before, an individual is not immune from the taxes. Also, there is the cypre doctrine, which I just want to mention, and that's interesting. And I've had a couple instances where this happened, where a charity no longer becomes viable. It kind of goes out of business. So what you have to do is so now you've got money. It's like a car without a driver. You've got money, but nobody to give it to, right? So you'd have to go to court, and you would have to say, listen, this is what the beneficiary, or this is what the testator wanted. He wanted it to go to, helping animals, specifically dogs. Okay. And this charity that he named, the specific charity, no longer exists. But we found this other charity that's and you convince the court that it's similar and will kind of meet the intent of the beneficiary. And the court says, okay, fine. Since the other charity is no longer in effect, we're gonna go. You're okay to go forward and give this bequest to this charity. The opposite would be that if it's not in effect, it would lapse, which means it would go back into the residuary estate and be split by, your three children, as just to continue the example from before. Or you may want to just put like an alternative, like if this doesn't exist, this one charity doesn't exist, then I'll leave it to, or if the local charity of the Salvation Army, West Orange or whatever brand, whatever, no longer exists, then I want to give it to, the East Orange version or the national version. So anyway, you just want to be specific and provide, because you know what, charities don't always last forever.
Dentro de todo esto también se debe destacar muy detalladamente la situación de los beneficiarios. Por ejemplo, también si se les quiere hacer donaciones a las diferentes fundaciones u organizaciones, es muy importante ponerlas, y también agregar, por ejemplo, qué sucede si esta fundación o organización se cierra en algún momento, hacia dónde va a ir ese dinero.
Personal residence. You want to think whether you want to give it outright to your beneficiaries, or if you want to just put it in a life estate. And just as an example, this is where you see people leaving a life estate. Say it's a second marriage, okay? The husband died. The husband, is on the second wife, has kids with the first wife, and the second wife and the husband are living in the house. The husband dies, and the husband wants to provide and doesn't want the wife to have to leave the house right away. He doesn't want it to go to her, but he doesn't want to like basically have her kicked out. So he can leave her a life estate, which means that she can live there, as long as she wants, and or he can provide that she can live there for 10 years or 5 years, just to provide for her. And then upon her either vacating or her death, then it would go to the children of his first marriage. But anyway, those are just all kinds of options that you can that you can avail yourself of. And I just wanted you to be aware of it because so we see that a lot, where and there I'm sure there's other instances too, but that's probably the most popular one, the example that I just gave.
Entonces, las diferentes opciones están junto con lo que son los legados específicos, los bienes inmuebles, las cuentas bancarias, los legados benéficos, que son los que hablamos como los de las organizaciones benéficas, en donde también se pueden dejar dentro de una cuenta IRA, o también lo que es la residencia personal, en donde se habla si la propiedad es absoluta frente a la propiedad vitalicia, y también se discute, por ejemplo, la situación en diferentes matrimonios o hijos de diferentes matrimonios.
Okay, use of generic terms. Children, grandchildren, issue and descendants.
Hi, MJ. Because of time, we're going to go to the Q&A. We have to jump. We're over an hour already.
Oh my gosh, I'm so sorry.
It's all good. It's all good. It's a lot of good material. I'm going to put you on the spot now, MJ. And I know because of your knowledge and PPAC's knowledge, you're going to be able to answer this very succinctly because we're on a time clock. It's a very broad question. So I know you're going to do it. Could you explain the difference between a will and a trust?
Sure. A will is a testamentary document, okay? In other words, it doesn't speak until you pass away. So it's not valid until you pass away. And why it can be confusing is you can also have a testamentary trust. Your will can create a trust, but obviously the trust is created under the will, and the will isn't created until the will isn't valid until you're dead. So therefore the trusts aren't valid until you're dead. A trust under agreement, which is also called an Intervivos trust, while you're alive trust, can be, as soon as you create it and fund it, it's a living document. Okay. So it can, and you can provide for, and different people, and there's just a myriad of different kinds of trusts for tax protection and asset protection that you can create. But that's basically the difference between a trust and a will. But as I said, it gets a little tricky because you can have trusts under will.
Sure. Tatiana?
Entonces, una pregunta que se realizó es cuál es la diferencia entre will o trust, entre un testamento y un poder fiduciario. Y básicamente el will es válido una vez que la persona fallece, mientras que el trust es mientras una persona está todavía viva. Un will sí puede tener parte de un trust, pero no viceversa.
Great. What I'm going to ask our viewers to do is please, and I know a lot of people are going to watch this on the re-recording and the rebroadcast, send any questions. We'll get them to MJ. She's very knowledgeable. You could tell she's very passionate about the subject. And it's, at the end of the day, it's a very important document. It's a very important process. You should go through the exercise. I know my reluctance with my family. It's always hard to sit down and do it, but you just got to do it because not doing it could cost you a lot of money, a lot of time for your family, and that's just not fair. So we're offering some free advice from experts. Take us up on it. And thank you, MJ. Thanks, PPAC, for a beautiful presentation, and God bless everybody. And Tatiana, can you just repeat kind of what I said to folks as far as the ability to send questions and want via email?
Sure. Gracias, Carlos. Básicamente, si tienen alguna otra pregunta, nos las pueden dejar saber a través del correo electrónico, aprovechando que tenemos estos consejos de los diferentes expertos.
Thank you, everybody. God bless and enjoy this beautiful weather outside.
Thank you.
Gracias.
Take care. Bye now.